it says that please find enclosed here with copies of documents. The pre-dispatch inspection reports of the 7.5 meter, 8.5 meter, and 9.7 meter PSC polls carried out at Makamaika Industries IID Center, Dolgaon by the AGM-RE. So and so on 12th and 13 April 2017, as well as 27 March 2017. The polls used as test specimen for inspection were selected at random basis from a batch, and on passing the inspection, the entire batch was given clearance for dispatch. Also from the inspection reports, it is clarified that for 7.5 meter PSC poles, 12 numbers GI wire was used.
Whether you have decided that representation or not.
That instruction, Lordship, I have to take.
Representation, the PIL was disposed of with the direction to dispose of the representation.
Lordship.
Whether you have disposed of that representation or not.
That instruction have not been furnished to me.
So what you have done now? What you have done?
Lordship, I have received a status report regarding
What is the status report? Whether the representation was decided or not?
that. Lordship, no, that has not been decided yet, Lordship. I have to take instructions on that, Lordship. Whether that is...
What instructions? This was the contempt petition that the court has given a direction that decide the representation within time bound period. You have not decided. This is what the contempt petition is.
Lordship.
So what to do with the status report? And in July 2024, we have granted you time to ascertain whether that representation was decided or not.
Lordship, kindly...
So what do you mean by it's too much? Then we'll call the officer concerned who has not decided.
Just
that.
one last opportunity.
What do you mean by last opportunity?
To place the instructions as to whether the representation was...
Tomorrow. File your status.
Obligement.
Then at concept of the contempt is granted last opportunity to apprise this court whether the representation filed by the petitioner pursuant to the direction given by this court on 18/10/2023 in PIL number 67/2023 has been disposed of within the stipulated time or not. This tomorrow.
Obligement. Item 2.
Please, my lords, I beg to appear for the petitioner. As per the last order, we were directed to do dusty service on respondent number 8 and 9. Order dated 4th December, my lords. We've done dusty service. Respondent number 9 has passed away. He was the secretary of respondent number 8. And we have served respondent number 8 now, my lords.
There is no requirement of including new secretary as a party respondent.
My lords, once the association is a party, then there would no... It would be represented through its secretary only by implication, my lords. I don't see a need to impede them separately again. It's the same person, one and the same.
Still, and it comes to the applicant has submitted that the notices upon the respondent number 8 has already been served, which is a society, whereas the respondent number 9 was the secretary of the said society. It is submitted that the secretary of the society, the respondent number 9 has now expired, and therefore expired. However, when the society itself has already been, when the notices upon the society itself has been served, there is no need to substitute the respondent number 9 with the new secretary. Stop. An affidavit. Additional, an affidavit is filed on behalf of the applicant. Submitting proof regarding the justice service upon the respondent number 8. Stop. Taking into consideration the acknowledgement report annexed along with the affidavit, we deem it appropriate to read the service of notice upon the respondent number 8 as complete. The respondent number 9 since expired, the service of the condition of service of notice upon it upon respondent number 9 is waived. You are appearing,
I'm appearing for phone number 8, Lordship.
Mr. So is appearing on behalf of the respondent number 8. Let this IA is for what?
My lords, there are two IAs. One is for condonation of delay. If my lords will see the first order of 1st of May 2024, my lords was of the view that perhaps the application seeking permission to file the appeal ought to be considered first before the delay can be condoned. That IA is, my lords, 1367 of 2024 for permission to file appeal.
What do you mean to say? What do you want to say?
Lordship, I would like to file objection regarding the delay, Lordship.
My lords, it's
Sometime
a
may collect.
53-day delay only. It's not a very large delay. And
Let them file a reply if they are asking for that.
I have no difficulty, my lords. Only request is that the race is in January. So if they take more time, then this entire
Okay, then
exercise will be.
Appearing for the respondent number 8 seeks time to file reply to the IA number 1367 as well as IA number 1194 of 2024 list after 2 weeks,
Okay.
3 weeks.
Deeply.
Can I request for a fixed date, my lords?
You ask the court master then.
Please, my
I'll
lords.
give. Item 3.
Respondent number has not been served.
Lordship. Lordship, fresh notice me.
The notices issued to the respondent number 1 as no sole respondent has not been served since long. Learned counsel for the applicant is directed to take fresh steps for service of notice upon the respondent number upon the sole respondent to register daily and thus the requisites be filed within a period of 1 week. On filing of the same, let notices be issued to the sole respondent returnable for 6 weeks thereafter.
Lordship.
Item 4.
Next, please, Your Lord. In this case, my lord, is IA for condonation of delay for 87 days, my lord. In the meantime, my lord, a similar matter your lordship dispose of, my lord. By condoning the delay, my lord, similar pair, my lord. Only change, my lord, on delay for 87 days.
Just
No, 537 days that case, my lord. My case is
just
for
a minute.
sorry.
Same order कर दे लेगा जहाँ पे 500 and something days है इसके 537 और 487.
Marchable.
Item number 5.
My lord, the said service has been taken only, my lord, the affidavit regarding the acknowledgement of the steps taken by the dusty could not be filed. Affidavit regarding the
So
acknowledgement,
when you are going to file,
my lord, after vacation, my lord.
Learned counsel has submitted that the affidavit regarding the justice service of notice upon the respondent would be filed by the next date of hearing, within 3rd week of January.
Item 6.
Early hearing of the petition?
Yes, madam. There is one, this matter, we have, for the private respondent, a PL was filed by this court. And on the basis of an order of a notification issued by the state government in 2018, by the time when the PIL was filed 2023, this order was not in, this notification was not in existence. 17th of February 2018. And my lord, this was not brought notice to the court that 17th of February 2018 notification has been all been
Who is appearing for
superseded.
the respondents? Your opinion?
I'm for the pollution control board. The petitioner is.
That is a
PIL petition,
Yes.
you have, all the other respondents are represented.
All represented.
Do you have any objection in getting it early listed? The matter comes up for consideration of the IA number so and so with a prayer to preferred on behalf of the respondent number 4 in PIL petition number 32 of 2023 with a prayer to list the above referred PIL at an early date for hearing. List an early date. Which of the counsel for the respondents has no objection and non-applicants has no objection if the matter will be listed at an early, if the PIL number 32 of 2023 be listed at an early date. Let the PIL number, hence the IA is allowed. The PIL number 32 of 2023 be listed on
First week of January anyway.
7th of January.
7th of January as prayed.
I am deeply obliged.
PIL, no, we are not taking into consideration the PIL. How the interim order can be?
That the notification, because when it was moved, my lord, that notification was not in existence.
Let us see.
Yes, your lordship decided.
Highly
Deeply
obliged.
obliged.
Item number 7.
May it please your lordship, it is an IA for condonation of delay of 16 days.
Notice returnable 6 weeks. That's the, yes, you are appearing.
I am from 2 and 4, Lordship.
Notice, Mr. So-and-so put in appearance on behalf of the respondent number 2 and 4. Let notices be issued to the remaining respondents returnable. 6 weeks, registered AD so.
Much obliged.
Registered AD and Dasti both.
Much obliged.
For admission, item 8.
My lord, the petitioner has been dismissed from service. And my lord, he has filed an appeal before the departmental authority. That is not been decided. And presently he is not getting anything.
He's dismissed, how will get anything?
He is not getting with his own GPF where he has deposited.
Sir, if he is dismissed from services, how will get anything?
So my his appeal is pending. My lord, let it be decided by the authority by the time of meeting.
Wow, who has prevented it? By this order, it is not, there is no restraint order that they will not decide it.
But they have not decided yet. But the appeal is pending.
That is, here we are, reviewing the order of the learned single judge. What's the wrong in that order of the learned single judge?
Wrong, my lord. Yes.
Provision of law, sir.
Mhm.
Once you are convicted, your services can't be continued. Has to be terminated.
He has retired otherwise, my lord, and just on the eve of his retirement, he has been, my lord, given this dismissal order. And he has submitted the appeal against that order, my lord, that may be
The
decided.
court has already ordered. The dismissal of the not standing in the event the petitioner is found to be entitled any amount towards subsistence allowance for the period, the same shall be computed and released. This order is also there.
Subsistence allowance, they have paid, my lord, but the,
Then what remains?
but GPF, his own money, GPF is,
And it's altogether a separate cause of action. How we are there? I think here, you have not questioned that. You have simply questioned your termination order.
no, my lord, in the prayer we have made, my lord, in the writ petition.
Here. This writ appeal is preferred on behalf of the appellant being agreed with the order dated, judgment dated 20th of June 2024 passed by the learned single judge in writ petition number 3403 of 2023, whereby the writ petition filed by the petitioner has been dismissed. The writ petition filed by the appellant has been dismissed. The appellant has approached, the appellant has approached the writ court being agreed with the order dated 31st of March 2023, whereby the appellant's services were whereby he was dismissed from the service on his conviction in a criminal proceedings initiated against him. Full stop. The respondents, by invoking the provisions of Article 3, invoking the provisions of proviso to Article 311 in bracket 2 of the Constitution of India, read with Rule 10 of the Assam Services in bracket Disciplinary and Appeal Rules 1964, has dismissed the services of the appellant. Full stop. The learned single judge has held that there is no illegality in the decision of the respondents imposing the penalty of dismissal against the appellant, and the action of the respondents is perfectly in concurrence with the proviso to article, second proviso, not proviso to article 311 in bracket 2 of the Constitution of India, read with Rule 10 of the Assam Services Disciplinary and Appeal Rule 1964. Full stop. Having heard the learned concept of the parties, and after going through the material available on report, we don't find any infirmity in the impugned order passed by the learned single judge, hence no case for interference is made out. The writ appeal is dismissed.
My lord, liberty may be given, my lord, because if the criminal case is pending before this honorable court.
That is
after-
always there. That is a separate cause of action. How you are seeking liberty in that?
Item 10.
Late please, your lordship. Lordship, this is a pensionary benefit here, pensionary benefit case, your lordship, passed by the, I'm infringed by the order dated 7/6/2024, passed by the honorable single judge, your lordship, regarding non-payment of your pension, your lordship. Your lordship has found by this honorable single judge that he has not gone through appropriate authority, your lordship. So, lordship, as I have only a single submission, your lordship, that he has been working for 36 years, your lordship, and as though he is a layman, your lordship, he do not know the appropriate forum, your lordship.
Ma'am, your client is sought regularization on the strength of the order dated 10th of February 2022.
Lordship,
By his
lordship.
services were regularized.
Lordship,
Show us that was by the competent authority with the prior approval of the finance department. Will grant you the relief.
that's what, your lordship, but he has been regularized, your lordship, by the executive engineer PWD, your
He was
lordship.
competent or not?
That's a lordship, but he should go
Then
through the.
how you can seek this pension on the basis of that regularization?
Rest I depend upon you, your lordship, but he has been a layman, your lordship. He do not know the appropriate authority from where
Whatever
to
it
go
may
through,
be,
your
ma'am,
lordship.
it's simply because he is a layman and he is not aware of that.
So he should go
That
through an
can't be a
appropriate.
ground. That can't be.
Rest I leave it on your lordship, as lordship may then pass an
What-
appropriate order, your
What
lordship.
else, what else view will take in this matter? Will say that despite his regularization was not in accordance with law, he is entitled for pension. And
Lordship.
it may open the floodgates. That would be.
That's all your.
This intra-court appeal is filed by the appellant being agreed with the order dated 7/6/2024 passed by the learned single judge in writ petition number 2065/2023. Where the appellant has approached the writ court with the grievance that despite regularization of his services by order dated 10/2/2022 passed by the executive engineer PWRD. Tapol Thana Territorial Road Division. The respondents has not granted the pensionary benefits to the petitioner after his retirement on attaining the age of after his retirement from the services on 28/2/2022. Full stop. The claim of the appellant was registered by the respondents, claiming that the regularization order dated 10/2/2022 was passed by the executive engineer, who is not competent to pass such order, that too without the prior approval of the finance department. The learned single judge, after taking into consideration the above fact situation, has come to the conclusion that since the regularization of services of the appellant was not in accordance with law, he is not entitled to get any, it cannot be deemed that his services have been regularized, and on account of that, he is entitled for the pensionary benefits as payable to a regular employee. Full stop. Learned counsel for the learned counsel for the appellant has failed to persuade us to take a different view as has been taken by the learned single judge. The learned single judge has already observed that the appellant is entitled to get the appropriate reliefs in accordance with the learned single judge has that the appellant being a casual worker would become entitled to payment of gratuity and other retiral benefits in accordance with law. Hence, we don't find any case for interference. The writ appeal is therefore dismissed.
Oblige, your lordship.
Item 11.
My lord, the order, my lord, the learned single judge is challenged, my lord, on the ground that, my lord, the resignation, my lord, in the instant case was never withdrawn by the incumbent, my lord.
No. It was not.
Because, my lord, the writ petition was not on the premise, my lord, whether the acceptance of resignation
No,
is.
the learned single judge has passed the order on the ground that prior permission for submitting resignation was not there.
But that was not the case in the writ petition. If my lord will take the prayer portion, my lord, of the writ petition, page 45 and 46. My lord, the challenge was made on the ground that the resignation was forceful. My lord will take prayer portion, my lord, at page 45 it starts from. And my lord, in the next page, the writ petition was, my lord, based on the fact that the resignation was forceful. Whereas, my lord, the incumbent has never withdrawn the resignation. Rather, my lord, he preferred a suit 1.5 years after, my lord, the resignation. So, my lord, once the, my lord, law is very well settled, as my lord knows, my lord, that resignation, unless it is withdrawn before the date of acceptance, that would attain penalty. And secondly, my lord, the learned single judge, my lord, erred in treating the resignation as a voluntary retirement. Because, my lord, as per Rule 26 of the CCS rules, my lord, resignation entails forfeiture of service. And in this case, my lord, the petitioner has not completed 20 years of service, which is mandatory under BSF to entitle him for pension. My lord, regarding the prior permission, my lord, under the rules, my lord, there was, my lord, once the application was submitted, the authorities have duly considered, and if my lord will take the order of acceptance of the resignation at page 27, that order
Yes.
Initially, when he was initially terminated from services, he was allowed to rejoin his services. Within a few months, my lord, termination, a resignation was forced out of him.
Force ka, what is the evidence of that force?
My lord, that is what
Resignation?
I'm coming to that, my lord. He filed a suit, my lord. The suit, he filed a suit. The suit was decreed in his favor, with the conclusion that it was in fact forced out of him.
But that ultimately.
That was with the detailed jurisdiction, my lord.
That decree was set aside.
My lord, yes, that was
The
set aside.
ground that
Then-
this, our court has no jurisdiction.
Then, my lord, when he
He
came before
preferred a writ petition, Punjab Haryana High Court, that was dismissed on the ground of territorial
Territorial
jurisdiction. Now he has preferred.
now he has filed, then he approached his honorable court in 2011. It was only on his approach in 2011 that that the respondents cleared his dues, which is supposed to be cleared in the year 2003 itself. That was one part of it. The second part, Lordship will see, when we argued the matter, to prove the forced resignation, the first thing that the learned single judge had asked us was, what is the procedure for resignation? The first procedure was he had to apply for a permission. Respondents could not show any documents on record to show that I had even applied for that part.
No, suppose if
So therefore,
you resigned on 8th of April, I think.
my lord,
And that resignation was accepted on 24th.
24th.
So that would mean that the permission was there.
The
Once they have
permission was,
accepted, it means they have permitted you.
no, my lord, what the learned single judge has found is, I have, the department which has trained me and has kept me in service. Once I tell them, because there's a procedure in the BSF rules also I can show, which says that I need to apply for permission to resign. That is what section 8 says. Once the department thinks it fit that I can apply, it is thereafter I apply and then they accept it or reject it based on the administrative grounds. Because resignation on the first stance itself, the administrative feasibility would not be seen. It will also be seen whether I have got a disciplinary proceeding, whether I have got something or else, whether I am resigning or whether I am resigning on my own, whether there's something else which is pressurizing me. All these things taken into consideration is what the learned single judge has held, that yes, had there been a permission,
Matter requires further comment. Look here. Learned concept of the
otherwise he has not got any benefit, 7 except that he will receive a pension now.
your pension, voluntary retirement and everything.
But that was only the
They-
reinstatement, the
Him to
reinstatement.
be voluntarily retired, learned single judge has come to this
No,
conclusion.
why it was come to it? Because if the resignation is wrong, then it was a reinstatement. We knew 20 years down the line, a person now reinstated would get nothing.
No, no,
It would not serve the
reinstatement, forget
country.
about it. Forget about it.
It's too late in the day to have it
Concept
reinstated.
appellate has submitted that. The learned single judge has failed to take into consideration the following. The respondent has never withdrawn his resignation which was tendered by him on 8/4/2023 before acceptance of the same on 25/4/2023. 3, not 23, 2003. Learned counsel has submitted that the conclusion arrived at by the learned single judge to the effect that before submitting the resignation, previous permission in writing of the prescribed authority was not obtained. It is contended that once the resignation is accepted by the authorities concerned on 24/2023, 2003, 25/4/2003, it would be deemed that the authority concerned has permitted the appellant to resign. Stop. It is submitted that in view of the above facts, the impugned order passed by the learned single judge is not liable to be sustained. Per contra, learned counsel appearing for the respondent has supported the impugned judgment and has argued that it is an admitted case that and has argued that as per Rule 8 of which rules?
BSF rules only.
Rule 8 of the BSF, Section 8 of the BSF Act 1968 clearly provides that no member of the force shall be at liberty to resign except with the previous permission in writing of the prescribed authority. It is submitted that it is an admitted case that the applicant, the respondent has never applied for resignation and the prescribed authority has also not, has never granted any permission for resignation. It is submitted that the factum regarding the forceful, regarding the forceful resignation by the appellant is proved by the respondent is proved in the before the civil court, and looking to this fact, no case for interference is made out. Having heard the learned counsel for the parties and after going through the going through the material available on record, we are of the view that matter required consideration, hence admit issue notice, no need to issue formal notice as the sole respondent is represented to list for hearing in due course. In the meantime, effect and operation of the ensuing order passed by the learned single judge shall remain stayed. Effect and order of the individual passed by the learned single judge dated so and so in the petition number 12 shall remain stayed. Final disposal of the writ appeal.
God bless you.
Item 12,
This is an appeal by the Tribhuvan University against the order of the learned single judge, my lord. Where, my lord, we have been directed to consider the entire period from the date of his initial termination to the
Suspension.
my lord, as suspension and pay him all the subsistence allowance. My lord, what is wrong is that, my lord, he in the writ petition issue, he never challenged the finding of guilt. He has not challenged the punishment imposed upon him. In those circumstances, my lord, if you go by ECL versus Karunakar, my lord, what the honorable court has said that the period that he'll be deemed to be reinstated is only for the purposes of continuance of the DP from the stage when it was remanded back. In such, and what the university has done is, my lord, from the date of passing of the final order, we have taken him to be retired. We have given him all the notional benefits. We calculate the pensionary benefits as on the date on which we pass the order. He gets all the benefit, all the areas as and where applicable. The only thing we had denied him was the actual pay for the, because he was found guilty of misappropriation of funds, my lord. In that circumstances, allowing him this benefit would actually give him, my lord, a premium for even
Services were dispensed with earlier
in 2004, my lord.
2004.
4. Then he approached this honorable court, matter remained pending. Honorable court found that while giving him the enquiry report, there was a indication that we were holding him guilty even prior to supplying him an enquiry report. Therefore, we were asked to give him the enquiry report with a fresh mind. That we did. We found him guilty. We told him you are guilty. Then we gave him another notice saying that this is the punishment proposed.
And then you have terminated, again you have terminated his service from the date, earlier date on which
That
you
was a
were-
misunderstanding of the department. We had considered in the court that it cannot be so. It has to be from the date on which we passed the orders. It cannot be date prior. So we considered to that, we gave him on that day, from the day on which the orders were passed, giving him notional continuity for the entire period for calculation of his pensionary benefits now, which would give him a very high rise in the pension. It would give him on the retired benefits also, the GPF, the DCRG, everything he gets on a higher rate now.
This was not the case before the learned single judge. You have not argued that.
My lord, that was what was given, my lord. Lordship will find. That was not recorded by the learned single judge, but our order, which was under the penalty order, my lord. If that finds, lordship. Yes, my lord. Lordship would find at page 77.
No, with the discussion on this point that you have granted him all the benefits. This is not the.
For notional benefits, yes, my
from
lord.
the order passed by the learned single judge.
No, that was there, my lord. Yes, my lord. Para 16.
16,
16, my lord.
yes, the
Having dealt with the said grounds, it has to be noted that the university authorities in its communication that 2523 had held that the period for the petitioner was claiming back wages would be entitled to be considered notionally for continuity of service or purposing for the purpose of calculating his terminal benefits. We said we are giving him the continuity for all the terminal benefits. That was discussed in short, but that was our whole case. We are giving him everything except
the
actual
order
pay.
of granting all these benefits.
My lord, yes. The impute order is yes. Yes, my lord. It is at page 72,
Based on the inquiry report,
my lord.
fresh representation for show cause notice reply received on 7 and dated all the connected documents.
I'm sorry, my lord, that is given from 2004.
As per the chart sheet, so and so, so and so.
And thereafter,
Let's go. Finance, Dindigul Dynasty, so and so, so on. With effect from the.
no, that was a 2000. I'm sorry, my lord.
There is no mention about it.
Lordship will give me 2 minutes, my lord. My pagination has gone wrong. Lordship will give me 2 minutes. I'll just trace it up. Just a minute, my lord.
First of all,
Just-
for the time.
Item 14.
Yes, state was supposed to pass some.
My lord, a little more time for the affidavit in opposition, my lord. It escaped my notice.
Last time you, this elementary education department, I think so you said, we are not aware of this, whatever the permission granted.
No, there was no permission granted.
Headmaster.
But there was no permission granted from our side. The headmaster was in a meeting with the GMC authorities who allowed that. So therefore, we have now asked him as to under what authority he had given that permission or even participated in the meeting. He's yet to give us the reply to that notice. Therefore, took some time. And then I missed it on the last week, madam.
Yeah.
The instruction from the
You will
municipal
listen.
board. The school management authority and municipal board, they have.
But ultimately, the property belongs to the elementary education department.
They have given the consent and handed over.
How? Under what authority? is
I
school
don't know
authority
that
can-
instruction I have.
Okay, Mr. Rajesh Majumdar, standing concept for the elementary education department, Assam, appearing on behalf of the respondent number 2, 3, 6, and 9, takes some more time to file counter affidavits. To file affidavit clarifying the extent of the education, elementary education department, Assam. List on so and so interim order passed by this court on 20th of December 2023 shall remain in currency till next date of listing. You may also file your reply, Mr.
My lord.
Yes,
21-1. Item 15.
May I please your lordships? For the respondent number 3, your lordship.
yeah.
On the last occasion, I taken some time from the honorable lordships. Due to medical reason, my senior has lost a younger brother. We are still on leave, your lordship. Kindly give me some more time, your lordship.
What is in there, matter?
My lord,
What is in this matter?
I challenge the judgment of order.
UGC regulations certainly are not applicable when there is separate regulations for that.
So far as the UGC concern, they are receiving the entire benefits of UGC under UGC, my lord.
Whatever it may be, once the Indian Medical Act, Indian Medical Central Council Act 1978 specifically provide that in respect of this staff and everything, these regulations will come into force. How this UGC regulations will come into force?
Well, so far selection is concerned, my lord, constitutional selection board concerned, my lord, there is no any in Indian
The
council, my
service
lord.
conditions are to be governed by that act only, not by the UGC regulations, where the UGC regulations in respect of other colleges may apply, but not in medical institution. We find that Learned Single Judge has rightly concluded that. Whatever it may be, council. So appealing for the, Mr. P. Das. Learned counsel appealing for the respondent number 3 has submitted that Mr. P. Das, MSP P. Das is in bereavement. Who is in bereavement? You are appealing for whom?
Respondent number 3, your lordship.
Respondent number 3 means there's some other advocate is appealing, your senior is appealing.
We are two advocates for the respondent number 3, BK Das and P Das, your lordship.
And BK Das is in bereavement.
Yes, your lordship.
MSP Das, learned advocate has submitted that the arguing counsel Mr. BK Das is in bereavement. And therefore, some more time may be granted. This after a PU vacation.
Deeply obliged, your lordship.
Respondent number 4 in
Deeply obliged, your lordship.
Item 16.
May it please. The appeal is on a very limited ground. Having recorded the findings,
He's appealing for the other side.
Hello, in this case, my lord, senior government advocate Dean Hartle appeared. Can be taken after vacation, my lord. He is.
Oh, answer this. Judgment was kept pending for 2.5 years, and in the meantime, they were retired. Therefore, they are not entitled for any relief.
I mean, any day after reopening, my lord. You know,
very limited. The findings have not been questioned. The findings are that there are gross illegalities in the selection process. How good this?
PU vacation. Mr. So-and-so for Mr. Peanut, please for an adjournment list after PU vacation.
Right.
Item 17.
My lord, immediately after obtaining, my lord, the common judgment, my lord, the authority has stayed, my lord.
In view of this single budget judgment, then nothing remains, nothing surviving.
My lord,
Is it a-
including only, my lord, that will do, my lord, including only area salary, my lord, we give.
That they have already, the Learned single is already.
No, my lord, the area part of salary has not been said.
The VRS dues of her deceased husband now receivable by the petitioner there herein be computed in the manner indicated above and released within a period of 3 months from the date of receipt or certificate copy of this order. All the dues, they have mentioned it.
Lordship receipt, he had received.
My lord,
That
yeah,
will
my
take
lord,
care of that.
yeah, my lord, why I am before your lordship by way of filing read appeal, my lord. There was a typing mistake in the case number.
That, forget about it. Now you got the relief. What remains in this? Why to pursue this petition?
Well, that might be more than this.
Yes, indicate that. In view of the fact that the in a writ petition filed by the appellant, in writ petition number 2193/2015 filed by the appellant, the learned single judge has already ordered that the respondents, the respondent department is directed to compute the VRS dues of the husband of the petitioner strictly in accordance with the notification dated 10/6/2024. We don't find any 24, and as such, nothing survives in this writ appeal. Hence, this writ appeal is disposed of.
Item 18 and 19.
Your lordship.
May it please, Lordship. May it please, Lordship. Lordship, in this matter, Lordship, Senior Counsel A.K. Bhattacharya used to appear, Lordship. So he is not having well today. So I am praying for. Can it be on after vacation, due vacation? Obliged.
Item 21.
Lordship, this matter, Lordship, I pray for some time, Lordship, not receive the instruction.
You're appealing for whom?
I'm for the respondent, Lordship. Respondent number
Okay, Mr.
1, 2, 4, 5, and
So
6.
appealing for the respondent phase for time two. File is response to the petition, time paid for is granted, yes. Adjourn.
Pass over Metro 12.
Lordship should find it at page 85, maybe. Page 85. The last two paragraphs.
Yes.
In view of the above, the university has come to the conclusion that you would not be entitled for back wages for the period between 31/12/4 to 2/11/16. However, since the Honorable Court has directed that the order of compulsory retirement would be effective from 2/11/16, you will be deemed to be in service for that period only for the grant of notional continuity for the purpose of calculating terminal benefits. The university, in consideration of your notional service till 2/11/16, has decided to refix your retired benefits accordingly.
Yes, and concept of the appellant has submitted that though the appellants have terminated the appellant has compulsorily retired the respondent with effect from 30th of December 2004, while order dated 2/11/2016, but later on, while order dated 2/5/2023, considering the representation filed on behalf of the respondent, Lachit Bhatt Thakur, the respondents have, the appellants have granted the notional, granted notional continuity of services for the purpose of calculating terminal benefits up to 2/11/2016, and has also decided to refix and has also decided and has also refixed his retirement benefits. It is submitted that in such circumstances, the finding of the learned single judge to pay him subsistence allowance, treating him in services up to 2/11/2016 is not liable to be sustained. Having heard the learned counsel, having heard the learned counsel for the appellant, we are of the view that matter required consideration, hence admit issue notice returnable, the two registered AD and thus the returnable on so and so. In the meantime, effect an order of the impugned, effect an operation of the impugned order directing the effect and operation of the order of the learned single judge to the extent of directing the respondents to pay the appellants to pay the subsistence allowance to the appellant to the respondent for the period that is from 31st of December 2004 to 2/11/2016 shall remain stay.
Now obliged.
Supplementary list for orders, item 28.
Met with the lordships. Tapi, you were supposed to file some affidavit or some.
Yes, my lord, we have filed.
When,
It was filed.
We'll do.
12/11/24, my lord.
that is on behalf of Akash Deep Parwa.
Yes.
Yeah.
My lord, basically what we want to say, my lord, the approach of the state government doesn't appear to be very serious, my lord. Okay. Now, the reason being, my lord, this inception report, which is annexed to the affidavit, my lord, it is dated, my lord, 21/8/24, sorry, 29/24.
20th of September.
Yes.
Yes.
And the work order was issued before that on 21/8/24. That means there was no tender. Now, my lord, allegedly some firm from Netherlands has been engaged, my lord, at the cost of, my lord, 12.12 crores and odd. And that is only for, my lord, planning and tendering. And that is going to take 9 months' time. By 9 months, the flood will again emerge.
This inception report is certainly subject to what you clarify.
Yes.
This work was granted or work order was given on 21st of August 2024.
Yes.
And pursuant
No
to that,
tender, no nothing.
and pursuant to that,
Yes.
they have prepared this inception report.
Yes.
So that is after around, you can say a month time, this 20th of September 2024. So within 1 month, pursuant
No,
to
well,
that
I'm not
work
on
order,
that.
they have prepared this.
I'm not on
inception
that, my
report.
lord. This farm was selected without any tender. And my lord, when international agency provides any fund, my lord, I have made that statement. If your lordship will kindly come to paragraph, page 187, my lord.
Yes.
Roman 3, para. The inception report has a lordship's got it, my lord, at page 187.
Yes.
The inception report was submitted to the government on 29/24, which means that the process for selection of farm for preparation of comprehensive master plan can only commence after 29/24. However, the work order for carrying out work was issued to so-and-so on 21/8/24, which was 1 full month earlier before 29/24. How is this possible? It indicates GMDA may not have adhered to the standard norm of ADB and World Bank for engaging international consultants. The details of tendering process adopted by GMDA for engaging the firm and the basis for deciding on cost of the project needs to be furnished.
It's right, but just a minute, again, for seeking clarification.
Yes, my lord.
This is the order 21/8/2024.
Yes.
it says, subject consultancy services or preparation of GIS-based comprehensive drainage master plan, detailed project report for Guwahati City, Assam, India, work order dated so and so, so and so.
Yes,
Now here in the next page, this inception report.
yes, my lord, one second. Work, page number 80, yes, my lord.
This inception report project consultancy services for the preparation of so and so, so and so, so and so.
Yes,
So after this work order was issued,
yes.
they have prepared this inspection report.
No, my lord, yeah,
Inception report.
and this scope, what is this scope? To prepare the tender, that's all.
We are concerned with that, how to tackle with this
Yes.
situation. If that agency, either you show us that the tender process and it's altogether different thing and we can require so we'll examine.
No, my lord, my perspective is very simple.
And first of all, if this agency is not competent
Hmm.
to do this work, you show us. Then we'll ask them to change that agency.
In fact, my lord,
The manner in which they have
in
granted this-
fact, we have made one statement, my lord. If your lordship, would please come to page 187.
Yes.
Yes.
We are
Roman
not
4.
disputing, sir. We are not disputing.
No, correct.
There may be some illegality in granting this work order and some violations are there. But immediately we are concerned.
What I find, subject to correction, my lord, I don't consider this to be an adversarial litigation. It is for betterment of the residents of Guwahati City.
That's all.
So therefore, let us not throw mud at each other. Let us see that something positive takes place so that people their condition is
Particularly if
ameliorated.
this agency is not competent.
Yes.
Then
My lord, what we have said is, my lord,
Yes.
Roman 5, para 187.
Sir.
Netherlands has never faced artificial flooding due to rains in the past. Country has good expertise on prevention of ingress of seawater, not control of floodwater due to rains. Instead, such cities such as Singapore, Tokyo, London, etc. have greater expertise on stormwater drainage management. Why input from such cities were not consulted? I am a conscious member of the public, my lord. I am posing a question. My lord,
What is the experience and?
Lordship, I have all the replies. I have all the replies. Now, by a order dated 7th August, Lordship was placed in a PL to appoint a amicus.
Yeah, yeah.
Fine. We have no difficulty on that. Thereafter, on behalf of the amicus, one gentleman, Akashdeep, who has a background of forest, he came and he gave a presentation. Till there, we have no objection. Now, this affidavit has been filed by Akashdeep, trying to make it as an adversarial litigation. So we have serious reservations regarding this affidavit by Akashdeep. I'll reply everything. I'll reply everything. I'll go to the merit also.
We are simply concerned.
We are also concerned. That is why I never
The
approach
timing-
now
For
whether
the
the
timing- Just a minute. For the time being, we are not considering the manner in which the award, the work order was given and everything. We are simply asking you this background of this company and the experience that.
I'm coming to that. Lordship will kindly give me 1 minute.
Yes, please.
Now, on behalf of the that gentleman, Akashdeep, the amicus is making some submissions. So we are having serious doubt whether it is an adversarial litigation or it is a public interest litigation or the intention for which this honorable court directed the appointment of the amicus. Lordship may reconsider it, number one. Number two, if there is serious allegations regarding the tendering or whatever we have done, they should have done some homework. RFP was issued on 18/12/2023. RFP for consultancy service for preparation of GIS-based comprehensive drainage master plan and detailed project reports of Guwahati City on 1 year ago. 4 participants were there. That Netherlands company Haskong, Shah Technical, Tata Consultancy, and Wapcos. Detailed procedure was followed. That is why I'm saying. Now they are trying to divert the whole issue. This is no more a case where the amicus can appear, Lordship. Let them file a case separately and we'll handle everything. We want that the problem of Guwahati should be. Therefore, when Lordship directed the amicus, we have cooperated. We allowed Akashdeep, and in our instructions, he was also allowed to participate in our discussion. Now we are not going to do that anymore unless with leave of this honorable court. He is exceeding his brief.
That's another thing.
That is precisely,
We
that
have
is,
simply
now on one hand, we'll invite him to give
We
us
have
advices, and the other hand, he is trying to scuttle the whole process without doing the basic homework. That is not permissible in my humble
Now,
submission.
just show, now this, on this, after this inception report, what measures you have taken?
Lordship, I have taken the instruction on this affidavit, which I found it's very serious objection to this.
For the time being, ignore it. Now,
Lordship.
what?
Then we'll give a proper report, because the thing is going on in the right direction. Absolutely on right direction. This flood took place, this exceptional flood took place in the month of August. We started this process last year, December itself, thinking that there should be a proper drainage system. And why this tendering process? First, we have to understand what are the requirements. Then tendering process has to start. That 12 crores will not be sufficient to do all the drainage in Guwahati. My friends should have basic knowledge about this before making any statement as an amicus.
Just
I know.
yes.
So, so there was a hard fought tendering process amongst these four, which were shortlisted. There were more persons who participated in the tender process.
and we are going in the right direction, we can give the updated status report.
Mr. Chaudhary.
Yes, my lord. My lord, before Lordship
Yes,
kindly,
sir, these affidavit,
yes,
so far as regarding that any other aspects, this comments on work order and inception reports are how this person to whom we have allowed to intervene,
yes.
looking to his expertise, how can he comment on this?
All right.
That tendering process is wrong
No,
and
no,
so
no,
on, so.
my lord will
So
kindly
it
come to.
means that we'll stall
No.
everything and nothing
No, my lord.
would happen, sir.
My lord, neither I nor this gentleman has got any pleasure of my lord being an, I never wanted to become.
Then, sir, this
No, my lord,
affidavit
if my learned friend has any objection to I being continuing as an amicus, my lord, I can withdraw myself. There is no difficulty.
He may have objection, he may not, sir. We are not commenting
No,
on that.
no, my lord.
We are on this person.
No, no, my lord, what I'm saying, please read page 187. What we have said.
Sir.
My learned friend is jumping to conclusion. Please see the last three sentences of para 3.
Yes.
The details of tendering process adopted by GMD for engaging the firm and the basis for deciding on cost products needs to be furnished. We posed a question. Then Milord will kindly come to para Roman 4.
Yeah.
Under these circumstances, it is not understood why GMD has engaged an international firm from Netherlands for preparation of the master plan. The reason for same needs to be furnished. My lord, what
Sir,
a normal human being will.
What business this person to whom we have allowed to intervene in the matter and to give his inputs regarding his expertise, so and so, what business he is having in questioning this? And even though he has a right to do so, but not in this petition, he can challenge it by a way of separate.
No, my lord.
If he is aggrieved
Since
by,
your lordship
he
is,
can challenge it
since
by-
your lordship is permitted him to intervene in the
Sir,
matter.
intervening the matter only for the purpose of this, that he should assist and to use his good experience for the purpose of solving this problem.
No, my lord, what has he said? He said that inception report is dated 29/24 and this, my lord, the work order was issued on 21/8/24. Therefore, as a
Sir,
normal.
that's another thing. You point out the loopholes in the inception report, sir.
Yes.
We'll consider it.
Yes.
That this
Now,
inception
what
report
this,
is nothing.
now what this inception report is all about, my lord?
Yes.
Kindly see.
Yes.
It pertains to two aspects.
Yes.
Planning and tendering. And for that 9 months is required. Only planning and tendering.
Sir, that may be.
So from September,
that
9 months will take us to May 2025. We'll have flood. That's why I said, my lord, the sincerity of the government may not be there.
This sir, he is right that how he can
No, my lord.
comment on all
No,
this.
my lord. My lord, if something is, my lord, end of the day, government has to accept, my lord, criticism.
Sir,
There could be
criticism,
constructive criticism, there could be partisan criticism. But if there is a constructive criticism, my lord, the government and its agencies must accept it.
Sir, at least if he is aggrieved or anybody is aggrieved, he may challenge it by your separate proceedings that these they are done and they are not done in accordance with law. Will consider and decide the same. But in this PIL, where the simple issue is that the people are facing very problem on account of this flood water, how to tackle with? And we are monitoring that. To whom they have granted this work order and said this is not the matter which at present is to be taken into consideration.
Then who is no, my lord, then which aspect of the matter will be looked into by this honorable? If a citizen do not have the right to point out that the approach may not be correct or may not be good enough.
Simply say.
All that he is trying to project is, my lord.
Inception report having certain loopholes simply because that it will take some 9 months time or year more. It may take another agency may take 8 months or that much of time.
My lord, for doing this work, we do not need an expert from Netherlands. There are enough consultants in locally available.
Sir,
that's why we say.
Altogether, you may question this, that why they have engaged this and when local people are there. But sir, ultimately, once they have engaged, let them do the work.
No, I'm not saying, we never say don't do the work. We say the manner in which it has been done.
Sir, that is-
Therefore, they are supposed to place
we
the
are
how
not
it has
going
been
to, sir.
selected. We have not said anything else, my lord.
Sir, at present, we are in only concerned with this, how to tackle with this problem immediately, so the people may get respite. That's the only thing. The manner in which or whatever in which you may file appropriate proceedings, the guilty persons would be dealt with in accordance
No,
with
Lord,
law, but not
No,
in these.
every time, why should we take that approach? A guilty person will be punished. Why can't we, at the threshold, raise the points? Well, at end of the day, what is the meaning of a public interest, my lord?
that's,
If a member of public cannot pose a question,
It can be tackled urgently also. File separate proceedings, we'll consider.
so I don't think, my lord, this gentleman has exceeded his brief as an, am I?
We have.
And my lordship will take an appropriate view of the matter, but my humble submission is, this gentleman as a citizen of this country has every right to point out in his perception what is right and good. Whether your lordships accept that or not, that's a different thing. But my lord, merely because Advocate General has said something, that does not mean, my lord, lordships will take that view into account. No.
Not at all, sir.
Yes.
We are
No,
not at
now
all
what he has said,
because
no, he has gone to the extent of saying that not only this amicus, sorry, me, and he also would not be entered any further. My lord, we don't have any pleasure of participating in this
We
proceeding.
also don't approve this. We don't approve this. That amicus curiae is there, and you'll certainly assist it, and we require your assistance. That's all.
My lord, we have seen how these projects are being flouted every time, my lord.
Sir, that may be.
If they have, what prevented them from making? We never said that no tender has been floated. We said that under the circumstances, they are bound to place before this honorable court how the process of selection. We have only questioned that. We never said the tender is not followed.
This is not the time. You can very well, this person can very well challenge the action of the state government by separate proceedings, but not in this. We are at present, we are concerned with the what steps the government is taking and what steps till now they have taken. That is what we want to ensure that.
Last 20 years, city is facing the problem. What the government has done, my
just
lord.
want to ensure so that in the next monsoon season, the people may not face such difficulties. That's the only concern. Okay. Pursuant to the direction given by this court, an affidavit is filed on behalf of the state government. Then the pursuant to the direction given by this court, an affidavit is filed on behalf of the state government, wherein it is stated that one agency is hired for preparation of GIS-based comprehensive drainage master plan and detailed project report. The Guwahati city and work order has also been issued to the said agency. It is further submitted that the said agency has already filed, has submitted the inception report, and as per the same, the work is under progress. Full stop. On 11/11/2024, this court has granted time to Mr. K.N. Chaudhary, rendered amicus curiae, to submit, to file his comments in respect of the additional affidavit filed on behalf of the state. Full stop. An additional affidavit is filed on behalf of one Akash D. Barua, to whom at one stage this court has granted, this court has allowed to intervene in the matter, looking to his experience while working as what he was at that time.
Beloved, he retired as principal chief conservator of Forest of Tamil Nadu.
While working as while holding a high position in the looking to the fact that he was holding a high position in the forest department. Full stop. In the affidavit, though concern is raised about the fact that the agency has asked for time ask for time to conclude the work, which may result in delay and which may result in taking corrective measures, which may result delay in taking corrective measures. However, simultaneously, the deponent has raised the question regarding the manner in which the work order was granted to the consulting consultating agency. It is also mentioned in the affidavit that several other indigenous companies are also capable of doing the said consultancy work, but ignoring them, this the consultancy agency from the Netherlands, which may not have experience in controlling artificial floodings, have been engaged. Full stop. At this stage, we would like to say that we would like to observe that at present we are only concerned with the measures taken by the state government for controlling the flood situation in the Guwahati city, for controlling the perennial flood situation in the Guwahati city. The manner of awarding tender and the selection of the agency is not the scope of this PIL. If advised so, any person being aggrieved by the action of the state government of awarding the work order to a particular agency and the money is spent in the said process, he or she is free to file separate. He is free to file separate proceedings in respect of that. Full stop. Learned the Learned Advocate General Mr. D. Sekia is directed to file the status report regarding the progress of the work undertaken by the consultancy agency by the next date of hearing. When?
Immediately after 15th of January, Lordship. Maybe on 21st of January.
22nd of January?
Lordship.
22nd of January.
Lordship.
22nd, I'll not be there. Could it be preponed or 2 days thereafter?
Then 20th?
20.
Or 27th?
27.
27th.
Highly obliged.
For final disposal, item 22.
Oh. Friends, the submits, we have received an affidavit in reply today, my lord. I'll be needing some instruction from the CS from the client. So
Bihu vacation. Bihu vacation.
Got you after that. Immediately.
Any date, Mr. Chaudhary? Any date?
Actually, my lord, there is no factually. I don't think he needs to have an anyway, my lord. Today I can understand there is some urgency, my lord. Could it be before Bihu, my lord?
Yes, sir. When?
My lord, 7th, my lord.
Seventh is the hearing day. Okay, seventh.
Milord.
Seventh.
Seventh, my lord, I'll have some difficulty, my lord.
Okay, then
Can be 13th.
13th.
13th হলে
13th.
13 January বন্ধ।
Vacation.
1/3 of
You
the-
vacation.
If he has got difficult, it can be on my lord 9th or 10th, my lord. 7th যদি আছে। ইয়াৰ একো বন্ধ আছে।
Yes, Mr. Sekia.
9th or 10th? 9th.
9th. 9th January.
Yes.
Deep left.